Okay, great. Welcome to the class. It shouldn't be a terribly long lecture today. We're doing Unit 11. Unit 11 is about agency. It's not a very long unit, but it is very important. It is extremely important because there are concepts in the law of agency in Unit 11, which when we get to partnerships, we start with partnerships on Thursday, specifically Unit 14 of partnerships, contractual representation of partnerships is heavily based on the law of agency. And when we get to Unit 14, I will be going quickly because I will assume that you understand the different types of agency. I'm not going to teach them to you again. And then, of course, next year, or next semester, when you do company law, we do contractual representation of companies. And similarly, the understanding of the law of agency is important for that. And I will assume that you know the concepts. So this unit is important not only for test purposes, but also it provides vital prior understanding, vital prior knowledge that you will need when we get to partnerships and companies. Now, why is agency, apart from that, why is agency in this unit? I've already explained to you, we started off with the basic principles of contract. And then we started looking at different types of contracts. Now, agency arises from a contract as well. It's also a specialized type of contract. I'm going to share my screen. Now, for tonight, I actually have a PowerPoint for you. Okay, while that is loading, if you can give me one moment. I have a student who is struggling to join the class. I just want to help her get in quickly. I'll be with you in a second. Okay, there are more students that are now WhatsApping wanting to suddenly be added to the group, but now I'm wasting everybody else's time. You should check these things in advance, not when the class starts. So, the law of agency, what are we talking about? In its most basic terms, let's say I give Roland some money and I send him to the shop to buy me a burger and a Coke. He goes to the shop, pays for a burger and a Coke, brings it back to me. Roland is my agent. That is agency in its absolute simplest of terms. In legal terms, what is agency? I'm going to skip over the learning objectives. What is agency in legal terms? So I'm just trying to set up the slides. So the concept of agency arises when a person, any person, doesn't have to be anybody specifically qualified, whatever, any person, when a person with the necessary authority, we're going to get back to that, that's an important part. A person with the necessary authority concludes a contract on behalf of another person who is known as the principal. Please watch out for the spelling of principal. It's P-A-L at the end, not P-L-E. So a person with a necessary authority, known as the agent, concludes a contract on behalf of another person, known as the principal. The manner in which this contract is concluded has the effect that the rights and duties, the rights and obligations that arise in terms of this contract accrue to the principal and not to the agent. The agent does not become liable and does not require any rights. If I sent Roland to go and buy me a burger and a Coke, he has to come give it to me. He doesn't get the right to eat it. If I sent him didn't give him the money and sent him to go and buy it on my account, the liability to pay for it remains my liability. He cannot be held liable. He is literally the go-between party. So the rights and duties that arise from this contract will be between the third party and the principal, as if the principal personally entered into this contract. There's a diagram for you explaining this. So you can see there that there's a bond between, a legal bond between the principal and the agent. The agent enters into a contract with a third party. The agent is authorized. The agent acts on behalf of the principal to contract with a third party, and the subsequent contract is then between the principal and the third party. Now, in order for this to happen, in order for this contract to come into existence between the principal and the third party, there are certain important requirements. Remember them. We're going to get back to them in partnerships as well. Firstly, the principle must exist. You cannot represent a non-existing principle. I see I've made a typo there on my slide. I'll correct the original slides. Secondly, the agent must be authorized. That is very important. There must be authority. And the third party must be informed. The agent must inform the third party that he or she is not acting in his or her personal capacity. With regard to that last requirement, there are some exceptions where we refer to the undisclosed principle, where the agent did not inform the third party. If the agent did not inform the third party that they are not acting on their own behalf, that they are representing somebody else, the principle will still be bound if, firstly, there was authority and the agent acted within the ambit, the limits of his or her authority. In such instance, the third party has the choice to then either, in case of breach of contract, to hold either the agent or the principal liable. So an agent who acts without disclosing the fact that they are representing somebody actually runs the risk of incurring personal liability. In such instances, also the principal may hold the third party liable unless the identity of the undisclosed principal is material, if the third party would not have contracted if they knew about that they were not dealing direct with the agent personally, but that it was a matter of representation. Now we get different types of authority, and you need to understand and be able to distinguish between these different types of authority. Firstly, authority is divided into two types of authority, namely actual authority on the one hand. Yes, Hedvig?
Miss, can you please maybe give an example of what you were just teaching now about the disclosed thing?
Okay, let me go back. Let me think. Hedvig, let's say you are selling a car and I'm interested in buying this car, and I appoint Jane as my agent to go to you, make you an offer on my behalf, buy the car on my behalf. Jane goes to you, but she doesn't tell you that she's buying the car for me. She just says 300,000 for the car, you agree. Now, subsequently, and you enter into an agreement that payment will be made at the end of the month. So it's a valid contract. Payment takes place at a later date. Nothing wrong with that. If when you find out that in fact Jane did not buy the car for herself, she bought it for me, you have the choice. The contract remains binding and valid, but you have the choice who to collect your money from, either from me or from Jane. So by not telling you she's buying it for me, she exposed herself to potential liability. That's essentially what it comes down to.
Okay, thank you, Miss.
Okay, please do ask your questions as we go along so that there are no misunderstandings. So we get actual authority and apparent authority. Those are the two main types of authority. There's either actual authority or apparent authority. Then you get two types of actual authority, namely express authority and implied authority. You need to be able to understand what express authority is and what implied authority is. You need to be able to recognize from a case study what express, if you need to recognize from a case study, from the facts of the case, whether the person representing the other person had express authority, whether they had implied authority. This is important when we get to partnerships. So what is express authority? Express authority is a specific instruction to act on behalf of another person. When I appoint Hedvig as my agent, I'm giving her, or let's say Jane, we used Jane just now, Jane represented me. When I appointed Jane as my agent to go and buy the car, that is express authority. I gave her an instruction. Jane, buy Hedvig's car for me for 300,000. When I gave her this instruction, there was in fact a contractual relationship arose between me and Jane. By appointing somebody as my agent, I enter into a contract with them. So obviously, you know what the requirements for a valid contract are. That agency, that appointment will only be a valid conferment of authority if all the requirements for a valid contract have been met. I cannot validly appoint Jane as my agent to go and buy Dacha for me. I cannot appoint Jane as my agent if she does not have contractual capacity. Must be valid. Although it's called express authority, it doesn't have to be in writing. It can also be verbal. If somebody was at some stage appointed as my agent and I reappoint them, the assumption is that they have the same powers as they previously did. If I'd appointed somebody as an agent and I replace them with somebody else, the assumption is also there that the new agent, sorry, the newly appointed agent has the same powers as the previous person. All of those details are not of such vital importance. What is of vital importance for you is that you must know, you must be able to recognize that express authority is a specific instruction, a specific authorization to conclude a specific contract. Implied authority, on the other hand, is authority that comes with the job. It is authority that doesn't relate to a specific contract, but rather it is broader, more general. It is authority that you gain by virtue of being in a certain position. Examples there, if somebody The guardian of a minor child has implied authority to contract on behalf of that child. Somebody that was appointed as the curator of an insane person has implied authority to represent that person. Partners in a partnership have implied authority to represent the partnership by virtue of being a partner. Directors of a company, in certain instances, not always, have authority, have implied authority to represent the company because they are directors. Get more detail about that next semester. Members of a close corporation, by virtue of being a member of the close corporation, has implied authority to represent the close corporation. The vice chancellor of NUST, by virtue of being the vice chancellor, has the implied authority to represent the institution. So express authority, oh, sorry, there was just some WhatsApps in the background again. Express authority. Just give me a second, please. Express authority, a specific instruction to enter into a specific contract. Implied authority comes with the job. You've got to recognize those two types of actual authority. Are you comfortable with them? Now, sometimes it can happen in a factual situation that somebody is not actually authorized. Let's go back to this slide first. The principle must exist. The agent must be authorized. If the agent is not authorized, if there is no authority, the general rule is that the principal will not be bound. If Roland goes on his own, without me having sent him, he goes to the shop and buys me a burger and a Coke and says, Miss Haneke will come and pay for it tomorrow. And he brings it to me. And I did not feel like eating a burger or drinking a Coke. What does your common sense say? Must I pay for it? I don't accept it. He brings it. I say, well, sorry, Roland, I didn't feel like eating it. Didn't want a burger. Must I pay for it? What does your common sense say? Would it be, does it make sense to you that I would have to pay for it if I didn't send him? He's now incurred $100 debt in my mind. Roland, what do you think?
No, it doesn't make sense, man.
Exactly, exactly. So I did not give you authority. As principal, I am not bound. Don't confuse that with a contract not being valid. The contract is still valid. There's a difference between a contract being valid and a contract being binding on the principal. I did not give you authority. Your common sense says, no, she doesn't have to pay it. The contract is still valid. The shopkeeper can hold you liable. But you did not have authority, so the contract is not binding. Understand that, people. We're going to get back to this. But now what happens if for a period of time, Roland was my agent? I'd appointed him as my agent. And every day he went to the same shop and he buys a hamburger and a Coke on my account. And the shopkeeper knows I also always come the next day or the end of the week, and I pay for the week. And then one random day on a Thursday, I have a fight with Roland and I tell him, sorry, you're not my agent anymore. Can't do this for me anymore. Roland decides, so now I've taken, he was authorized. Say he was my personal assistant. He had implied authority. It came with a job. Now I fire him, so to speak. So he no longer has authority. He goes to the shop, he buys a burger and a Coke on my account and eats it himself, drinks the Coke. Roland, put yourself in the shopkeeper's position. Because now, end of the week, I say, Roland, but I never told the shopkeeper that I fired Roland. Shopkeeper doesn't know. End of the week, shopkeeper says to me, Masano, come pay me. And I say, no, I don't owe you any money. Roland wasn't representing me. He didn't have authority. Roland, do you think this would be fair to the shopkeeper? He doesn't know where you are. He doesn't know how to get hold of you, to get the money from you. Do you think it would be fair for him? He acted in good faith. He believed you were representing me. Do you think this would be fair to the shopkeeper that now suddenly I say I'm not going to pay?
No, it won't be fair, ma'am. Is this where the shopkeeper can decide on who to hold liable?
This is, but yes, it is, but it goes further as well. The shopkeeper can decide, but maybe the shopkeeper doesn't know where you've disappeared. You've eaten the burger and you've disappeared. If he knew where you are, where to find you, he could decide who to hold liable. But now he can't find you to hold you liable. And he wants his money. You said it wouldn't be fair. Your common sense, your insight is 100% correct. And the law strives to be fair. And that is where the other type of authority, let's go back. We saw you get action authority, and we've illustrated express authority and implied authority. But there's also a type of authority called apparent authority, sometimes referred to as ostensible authority. The situation, Roland, that we've just discussed can be a situation where there is apparent authority. What is apparent authority? That is a situation where one person has represented, has created the impression that another person has authority to act on their behalf by, over a period of time, always paying what you bought. I created the impression that you had authority to do this. If a person has created a false impression, they become bound to the impression that they created and cannot subsequently rely on the truth to escape liability. By paying the account for months, I created the impression that you have authority. Now I cannot one day on a Thursday turn around and say, oh no, but he never had authority. I'm not going to pay. That wouldn't be fair, and the law strives to be fair. So I'm not bound because you were authorized, because you didn't have authority, but I am bound based on the principle, the concept of apparent authority. Putting this in different words, but the same that I've just described in fairly simple terms, let's go to longer words. The principal will be bound if he culpably created the false impression that another person has the authority to conclude certain juristic acts on his behalf, and the third party acted to his detriment on strength of that impression. Putting it in simple terms, if you create a false impression, you cannot subsequently deny that impression and try to rely on the true facts to escape liability. Obviously, this is law, so there are always requirements. What are the requirements for a third party to hold another person liable based on apparent authority? Firstly, representation has been made by the principal. It was a reasonable representation. The representation could reasonably have expected to mislead the third party. Third party acted on the faith of the representation, and the third party was prejudiced. So if those four requirements have been met, the third party will be able to hold the principal bound based on apparent authority. So, Roland, it differs slightly from the undisclosed principle. The undisclosed principle is a situation where the agent did not say they were representing somebody. So you didn't go and buy the Coke and tell them you are buying it for Miss Hanako. So the shopkeeper didn't know. Apparent authority, you informed the shopkeeper. The shopkeeper knew you were buying it on my behalf. The shopkeeper believed you had authority to do it because I had, by my previous conduct, created the impression that you are my agent and I will settle the account. So the shopkeeper can hold me liable based on the false impression that I created. Very important here is this false impression, this representation must have been created by the principal, not by the person who, not by the representative. If Roland had never bought anything for me previously, shopkeeper doesn't know him at all. He goes to the shopkeeper and says to the shopkeeper, I'm buying this for Miss Hanekom, she'll come and pay tomorrow. He brings it to me. I say to him, no, Roland, I don't eat meat. I don't want this. I'm not going to pay for it. Then the shopkeeper cannot hold me liable, because then it was you that created the false impression, not me. The principal will be bound if it is the principal. Your common sense will also tell me if you just go and tell a lie, I can't be held liable because of the lie that you told. But if I'm the one that created the false impression, I can be held liable. Questions? And then the last concept you need to know is the concept of ratification. Please note the word. The word is ratification. It is not rectification or rectification or whatever. This is a specific legal term, ratification. The verb is to ratify. If you spell it wrong, you're going to lose marks. Ratification would be the instance where Roland does not have authority. He's never represented me. I don't send him. He goes and he buys a burger and a Coke and tells the shopkeeper, Miss Hanekom will come and pay tomorrow. Shopkeeper gives him the hamburger and the Coke, believes him. He brings me the hamburger and the Coke. He didn't have authority, so by law, I can tell him, no, I don't want it, and I'm not going to pay. But that particular day, I rather fancy eating a hamburger. And I say to him, okay, thank you, I'll take it. And the next day, I go and pay. So there was no authority when he entered into the contract. But by accepting the contract, I have ratified it and I become bound. So ratification, instance where the agent acts without authority. The act is later accepted by the principal. And by law, it is then as if it has been authorized from the beginning, as if you originally had authority, and it becomes binding right from the beginning. Principal must ratify the whole transaction and not only part thereof. I either accept the hamburger or the Coke, or I don't accept either. I can't say I'll keep the burger and not the Coke. And it must take place within a reasonable time. Ratification, this can only take place, requirements can only take place in instances where the representative, the purported agent, not only intended but professed to be acting on behalf of the principal. So this is not an undisclosed principal situation. This is where Roland told the shopkeeper, I'm buying this for Ms. Hanekom. Principle should have been in existence. Once again, going back to the original requirements for agency, you cannot represent somebody that doesn't exist. And it's a contract, so there must be contractual capacity. That's the unit. That's what you need to know. Are there any questions? Hedwig?
Miss, I have a question, but it's not based on what you were teaching now. I would like to know if there's a difference between commercial law and accounting law, like between the one that we are doing now and commercial law. Is there a difference?
Yes and no. No, in the sense that law of contract is law of contract, law of contract. And in commercial law A, you also do law of contract. And the 5 requirements for a valid contract are the same whether you study them in commercial law or whether you study them in law for accountants. But content-wise, with regard to the syllabus, there's a big difference. Commercial law has 2 parts, commercial law 1A and commercial law 1B. Commercial law 1A, you do only the law of contract for a whole semester. So everything that we did from units 1 to unit 7, you do in commercial law 1A. It's spread over 17 units. It's a lot more detailed. And then you have commercial law 1B, where you do specific contracts, like purchase and sale, like urgent agency, like lease agreement. You cannot, however, and I've had students asking me this, so I just want to put it out there again. Commercial law 1A and commercial law 1B, even if you have passed both, will not qualify you to get exemption from introduction to law for accountants. Because starting on Thursday up to the rest of the semester, we do partnerships. And partnership, law of partnership is not included in either commercial law 1A or commercial law 1B. Does that answer your question?
Miss.
Okay.
Yes, Miss. Thank you.
Okay. Any other questions? Okay, I want to quickly stop recording, but don't leave the class.